Employee entitlements. In this short video, we will consider the legal entitlements of employees in Australia. Workplace relations in Australia are regulated by the Fair Work Act of 2009, which is federal legislation, and administered by Fair Work Australia. All employees in Australia are entitled to working conditions that are consistent with the national employment standards and the national minimum wage. Employees within a particular industry or sector will also be entitled to working conditions that are consistent with the relevant award. The employees within a particular organization may also be entitled to the working conditions that are set out in the negotiated enterprise agreement. And finally, individual employees may also be entitled to the working conditions that are set out in their individual employment contract. So we will consider each of these four types of protection in turn. So firstly, the National Employment Standards. These are a legislative safety net that apply to nearly all workers in Australia and provide for the maximum weekly hours of work, which is 38 hours per week plus reasonable additional hours, the right to request flexible working arrangement, so parents or carers of a child under school age or of a child under 18 with a disability are entitled to request a change in working arrangements to assist with the child's care. Parental leave and related entitlements. Employees are entitled to up to 12 months unpaid leave, as well as other forms of maternity, paternity, and adoption-related leave. Annual leave. Employees are entitled to 4 weeks paid leave per year, plus an additional week for certain shift workers. Personal or carers leave and compassionate leave. Employees are entitled to 10 days paid personal or carers leave, 2 days unpaid carers leave as required, and 2 days compassionate leave as required. Community service leave. Employees are entitled to unpaid leave for voluntary emergency activities and leave for jury service, with an entitlement to be paid for up to 10 days for jury service. Long service leave. Employees are entitled to long service leave after serving a particular period with their employer. Public holidays. Employees are entitled to a paid day off on a public holiday, except where reasonably requested to work, and notice of termination and redundancy pay. Employees are entitled to up to 4 weeks notice of termination and up to 16 weeks redundancy pay based on length of service. The national minimum wage applies to all employees not covered by an award or an enterprise agreement. It's currently $640.90 per week before tax, or $16.87 per hour. Casual employees are entitled to a minimum of 15% loading to reflect the fact that there are many other entitlements which they don't receive. Lower rates are prescribed for junior employees, apprentices, and trainees. An award is an instrument prescribing employee entitlements and working conditions within a particular trade, occupation, or industry. It sets out minimum employment standards that apply in addition to the national employment standards and is usually the result of extensive negotiations between employers, employees, and unions within the particular trade, occupation, or industry. If an employer fails to recognize the minimum entitlements of an employee under an award, they may be prosecuted for breach of the award. Modern awards do not apply to high-income employees. Employers and employees are encouraged to negotiate agreements collectively and enter into enterprise agreements. So in most cases, an enterprise agreement will be made between an employer and some or all of their employees. All enterprise agreements must be approved by Fair Work Australia before they commence operation. Fair Work Australia will apply the Better Off Overall test to ensure that each employee covered by the agreement is better off overall in comparison to the relevant award. And finally, employment contracts. An employment contract is an agreement between an employer and an employee that sets out the terms and conditions of their individual employment. A contract can be in writing or verbal. An employment contract cannot provide for less than the legal minimum set out in the national employment standards, the relevant awards, or enterprise agreements. Workplace health and safety. The employer must take all reasonable practical steps to protect the health and safety at work of their employees. They also owe a duty to other people at or near the workplace, such as suppliers, visitors, members of the public, and tradespeople, to ensure that they are not exposed to risk to their health and safety. The duty of care is imposed upon employers by tort law as we saw in earlier topics in this subject. The statutory workplace health and safety regime sets out in detail what it means for an employer to take reasonable care to protect the safety of employees and other people. Workers' compensation legislation provides for the compensation and rehabilitation of employees who suffer work-related injuries. So at common law, as we saw in earlier topics, if an employee is injured in the course of their employment, they have a right to seek compensation from their employer. But if we required all injured employees to commence legal proceedings against their employer and to prove that their employer was negligent before they were able to receive compensation, there are, of course, many employees in Australia who would never receive compensation. So what we have instead is a compulsory workers' compensation insurance scheme. The workers' compensation legislation requires each employer to obtain workers' compensation insurance from a licensed insurer covering them for liability for such claims. If they fail to insure all of their employees, they will be fined. So this means that an employee who is injured at work does not need to actually sue their employer in order to recover compensation. They can simply make a claim under the workers' compensation insurance. Employees are also entitled to protection from discrimination and harassment while they are at work. Unlawful discrimination occurs when someone is treated less favorably because of their race, color, national or ethnic origin, sex, pregnancy or marital status, age, disability, religion, sexual preference, or membership of a trade union. A good example of an employee who was able to establish unlawful discrimination by an employer is Wardley and Ansett Transport Industries. Ms. Wardley unsuccessfully applied for a position with Ansett as a trainee pilot. All of the successful applicants were male, including at least one applicant who was less qualified than Ms. Wardley. The Victorian Equal Opportunity Board decided that Ansett could not rebut the presumption that the decision not to employ Ms. Wardley was on the basis of her sex. Ansett was ordered to employ Ms. Wardley as a trainee pilot. Unlawful harassment occurs when an employee is made to feel intimidated, insulted, or humiliated because of their race, color, national or ethnic origin, sex, disability, or sexual preference. The employee is entitled not only to a workplace free from discrimination and harassment by their employer, but they are also entitled to freedom from discrimination and harassment by their co-workers. An employer will be vicariously liable for any discrimination or harassment by others that takes place in the workplace unless they can show that they've taken all reasonable steps to prevent and to address such discrimination and harassment. In Hill and Water Resources Commission from 1985, Ms. Hill was employed as a clerk by the Water Resources Commission. She complained to her supervisors about the conduct of her male co-workers. This conduct included sexist remarks, displays of offensive material, nuisance phone calls, and threats to kill her pet fish. Her supervisors did nothing about the complaints. The New South Wales Equal Opportunities Tribunal found that the hostile work environment amounted to sexual harassment and that the Commission was vicariously responsible for the conduct because they knew about it but did nothing. Ms. Hill was awarded substantial damages. Termination. As a general rule, an employer must give an employee notice of termination. This requirement is set out, as we saw earlier, in the National Employment Standards. It's also consistent with the provisions of contract law that we considered earlier. The employer may be entitled to terminate the employment contract without notice if the employee is in actual or anticipatory breach of a condition in the employment contract or the employee is neglectful or incompetent. Termination of employment will, however, be unlawful if it is because of the employee's race, color, sexual preference, age, physical or mental disability, marital status, family responsibilities, pregnancy, religion, politics, nationality, or social background, or if the employee was temporarily absent from work due to sickness or injury, or if the employee is or is not a member of a union, or because the employee is involved in legal proceedings against the employer. If an employee is dismissed for any of these reasons, they will be entitled to bring legal proceedings against the employer for unlawful termination of employment. Further, if the termination was harsh, unjust, or unreasonable, the employee may be entitled to lodge an unfair dismissal claim with Fair Work Australia within 14 days of the dismissal. This imposes a legal obligation upon the employer to ensure that when they do terminate the employment of an employee, that it is done in a reasonable and fair way. There are exemptions. It doesn't apply to employees who have been genuinely made redundant, employees who have been employed for less than 6 months, employees who have been employed by a small business for less than 12 months, casual employees, and highly paid employees.